Hi, Bell Henshaw again, Constitutional Coop Headquarters, and I'm going to go out on a bit of a limb here and say that it looks like I found where our judicial courts are, and they have to be there, people, not these legislative BS tribunals you've been in. Judicial courts, we can go in there, make our case, we have status and standing, and we can whip their ass every time in that setting. Not only that, but attorneys can't even come into our judicial courts. I've been reviewing the Judiciary Act of 1911, and I found in there that it said basically verbatim that they did away with the federal circuit courts, but that all of that jurisdiction and venue was transferred to the district courts. And that makes a lot of sense based on what I also know about this situation with federal courts. And you'll learn a lot about that. Send me an email, unincourt@gmail.com, for information on my modestly priced constitutional defense document packets. But this makes sense, especially when you consider that in 1925, the Judges Act, and embarrassingly, the four horsemen who were all on the court at the time were involved in this act. They cut back on the workload for the U.S. Supreme Court, but they did it in the wrong way. That said, they effectively did away with the writ of error, which was the common law remedy, and up until that time, you and I had a right to present our case to the court of the nation, just like John Marshall said in Cohen's v. Virginia in 1818, my favorite decision, and for more than just that reason, that the Constitution gave to each person a right to present his case to the court of the nation, no matter how little small the claim or how little interest the community in its outcome. The framers of our Constitution thought it important in the interest of justice to create a tribunal as superior to influence as possible in which that claim might be decided. That's the original intent, and the only nation ever set up life, liberty, and pursuit of happiness. It recognizes the dignity of man, the rights of man, and that he's important in and of himself. That's what's been lost over the course of 2 decades, although the Supreme Court, as I said, in 1920 and 21, has mentioned this Cohen's case in what looks like dissenting opinions, but they're not dissents. And you can't mention that case without what I just read and a lot more about that case. But the big deal here is that those judicial courts have to exist. If they don't, and on federal and state levels in sovereign independent states admitted into this union, all laws on the books, even if otherwise properly there, and none of them are, as you will learn, send me an email, unincourt@gmail.com for information. You're going to love it. They're not there. They're dead bang bills of attainder, the taking of life, liberty, or property without judicial process. No judicial court, no right to trial by jury. You're in an administrative proceeding. And you tell me where the hell we made a voluntary, knowing, and intelligent waiver of any of our rights, let alone the right to trial by jury. Now we get into this federal circuit court, and it's in a federal district court, but it is a federal circuit court. You're going to love this. Now they're going to have to listen, because now in that setting, they are Article 3 judges, and they're bound by oath by this Constitution and laws enacted in the pursuance thereof. On this point, I was also reviewing a case called Yakus v. United States, 321 U.S. 414, and that was about federal emergency regulations back in the day at the end of World War II. Don't get me started on that one. But the opinion of Owen Josephus Roberts in this case, and this is significant because he was the switch in time that saved 10 years earlier when they started to approve all this BS enacted by the New Deal and Franklin Delano Roosevelt. But a solo dissent in this case. Listen to what he said here about these emergency regulations, and he dissented from this. Said it is one thing for Congress to withhold jurisdiction. It is entirely another to confer it and direct that it be exercised in a manner inconsistent with constitutional requirements, or what in some instances may be the same thing, without regard to them. Does this sound familiar like what's happening to you and their damn legislative tribunals and martial law courts? Goes on. Wanted to tell that Congress can require the courts criminally to enforce unconstitutional laws or statutes, including regulations, or to do so without regard for their validity. The way will have been found to circumvent the supreme law of the land, and what is more, to make the courts party to doing so. This Congress cannot do. Are you listening, Fancy Ngozi, up Chuck Schumer, Bitch McConnell? This is the original intent here. Even if you're lawfully in office, and we can prove none of you are, you're going to love this part. Zero qualified in the House or the Senate. Send me an email, unincourt@gmail.com. You'll learn all about this. Zero. Not just quorum to do business, race or relationship, you name it. Zip. We got nothing there. Nobody that represents us. And that brings up the 4 magic words. Where the hell is the consent of the governed? It's not there, but in administrative tribunals like you've been subjected to your entire life, it doesn't matter. They're not constitutional courts. They can't rule on it. Now I'm pretty damn sure I found a way to get exactly where that is that we have to get to and be able to do that. And almost certainly without opposition, because their attorneys, unregistered foreign agents of the City of London, BAR, British Accreditation Registry, can't come in there. And it may be certainly the corporations and even the people that look like you and me can't do it either, because they volunteered into the system, didn't they? And they've accepted benefits for decades. And like the Supreme Court says, and maxims of law say, he who accepts the benefit must bear the burden. They can't come into our judicial courts, and they shouldn't be allowed to do it. On the surface, it seems wrong, but then again, to the extent that we quote unquote volunteered, it was because the government fraudulently withheld all the terms in the agreement of the contract, whether it was social insecurity, a driver's license, business license, what have you. And license, by the way, the legal definition is permission granted by competent authority to do an act that without such permission would be illegal, a trespass, or a tort. Black's Fourth Law Dictionary. We don't need their damn permission to do anything. We created this whole government and the Constitution to secure the blessings of liberty to ourselves and our posterity. Other than that, you government workers, you stay the hell out of our way. That's what you're supposed to be doing, not interfering with everything we do up to and including apparently taking a crap in a government-funded bathroom, which these days affects interstate commerce. Yeah, it's about time for it to start changing, and we now appear to have a quote-unquote conservative majority on the Supreme Court that I anticipated, if not predicted, was going to do what they've done, especially with the COVID case, which didn't exist at the end of 2020 when I started out on this. But I realized if they're headed that direction, and the COVID case, if you don't know, they overruled on interstate commerce grounds. That's a big part of it for us. And if they're going that direction, we're going to be one of the first in line there making these arguments. And that's what we need to do to get our federated Republican form of government of defined and limited powers back. Simple as that. Send me an email, uwinnincourt@gmail.com, and I'll send you information on my goods and my materials and more about this particular issue. In the meantime, subscribe, like the videos, tell your friends, get the word out. The sooner we all start working together and get on the same page and cut out this divide and conquer crap they've been doing for way too long, the sooner we get these bastards off our backs. Thank you.